back. And so I believe that we're ready to go back on the record. And Ms. Riggs, you may ask your next question of this witness.
Thank you, Your Honor. Just to clarify for the record, I am still offering questions just as cross-examination proffered in response to the proffering of Ms. Strack's excluded report for purposes of appeal. Ms. Strack, I only have a few more questions, or a few more minutes of questions for you. In your expert reports, you are, again, when we left off, we were talking about how under Senate Bill 824, in order to be accepted, a voter has to submit a reasonable impediment declaration, correct?
Correct.
And a voter has to swear under penalty of perjury that they have a reasonable impediment, correct?
Correct.
And penalty of perjury means that if they are lying, they could be punished, right?
That's correct.
And Senate Bill 824 lists types of reasonable impediments, correct?
Yes,
That includes lack of transportation as one,
it does.
but there's no specified threshold for lack of transportation in the law, correct?
It's just lack of transportation.
Okay, so hypothetically, a voter who might have access to a car once a week and doesn't have ID, they may not think that they have a total lack of transportation, correct?
Well, that would be up to the voter to determine that. I can tell you that when we were implementing 589, we had those discussions, and if the voter believes they had a lack of transportation, then that should be accepted.
But it's sworn under penalty of perjury, correct?
True.
And same with work schedule. There's no threshold days per week a person has to have a problematic work schedule in order to claim that reasonable impediment, correct?
Work schedule is just what's in the statute.
So hypothetically, someone who works every day but Saturday might not want to swear under penalty of perjury that their work schedule prevented them from getting an ID when they have one day off from work when they could have gotten an ID, correct?
I mean, I can't speak to what calculation they would make about whether they would sign that. What you're talking about, not whether it would count, but whether someone would be prosecuted.
Well, you testified that this reasonable impediment process is less burdensome as in your report, I believe.
Yes.
You
Yes.
stated that this reasonable impediment process was less burdensome, and I'm just asking you some questions about the basis for that. But hypothetically, a voter has to be willing to swear under penalty of perjury that their work schedule prevents them, and they might not be wanting to swear under penalty of perjury if they have Saturdays off, for example.
I can't actually, I don't know how to respond to that. I'm not sure but also signing the provisional application is also subject to criminal penalties if it is signed and falsely.
Okay. And Senate Bill 824 also provides a reasonable impediment for other reasonable, quote unquote, other reasonable impediment, correct?
Correct.
But as we've discussed, there's no statutory definition of other reasonable impediment, correct?
I think the language in 824 is that you have a reasonable impediment if you could not present photo identification. So whatever reasons you believe you cannot present photo identification would be an impediment.
Sworn under penalty of perjury, correct?
Sworn under penalty of perjury, correct.
And under Senate Bill 824, the County Board of Elections shall find the provisional ballot valid unless the county board has grounds to believe the affidavit is false, correct?
That's correct.
But there's no definition of what would constitute grounds to believe the affidavit is false, correct?
It would require the 5 bipartisan members to determine that the declaration was false.
So hypothetically, if a voter lists lack of transportation and one of those 5 members knows that the voter has access to the car, that could be grounds for rejecting that reasonable impediment, correct?
That member would have to convince the other four members that provide evidence that that assertion was false.
In your report, in your declaration you submitted in this case, affidavit, you assert that a majority of the voters disenfranchised by House Bill 589 would have likely had their votes counted under Senate Bill 824. Isn't that correct?
Yes.
But this opinion is based on a number of assumptions that you're not able to actually confirm. Isn't that right?
I said likely. There were with the fact the free ID being afforded to them during early voting or the day after the election if they vote on election day, and could then get an ID and show that ID, which would satisfy the canvass requirement. Those types of things, I believe, would make it easier for those people to get an ID which would be acceptable and have their ballot counted.
Right. So for example, you talked about the voters disenfranchised in 2016. You looked at whether they voted during early voting, correct?
Yes, a number of them voted during early voting and some voted on election day as well.
Right, but you were assuming that if they voted on early voting, that they voted at an early voting site where a free ID would be offered, correct?
I was not assuming that. I was assuming that they would have the option to get one and go to the County Board of Elections, which is an early voting site, in order to get that ID.
So your assumption is that every voter can get to the County Board of Elections site during early voting, correct?
I'm not sure it's an assumption. It certainly would be my hope that there would be some way that those voters could get to a site in the county that had the ability to make the ID.
And you made some assumption. Oh, I'm sorry, Ms. Strack.
No, I'm sorry.
It blipped and I thought you were done.
Sorry.
Are you finished? Please do.
I am.
And you looked at in offering this conclusion that a majority of voters disenfranchised under House Bill 589 would not be under Senate Bill 824. You looked at whether or not those voters had driver's license numbers. Is that correct?
That was part of it, yes.
And you didn't look whether those driver's licenses were expired or otherwise acceptable, did you?
No, did not have that information.
And in your report, you assumed that voters at the Duke University polling site in Durham, whose vote did not count, would have been able to use a student ID under Senate Bill 824, correct?
Correct. I believe that with the student ID, acceptable ID, if they have that, they could certainly use it in this election, sure.
But you don't know whether those voters would have had a separate Duke voter ID, correct?
No, I do not.
And you also assume that people who left their ID at home would now, under SB 824, be able to get a free ID from their county board, correct?
That would certainly be an option for them. They would certainly have that option at the county board, at least at the county board office.
But at the time of your deposition, you had not looked to see how many of the individuals, you claimed 1,367 individuals disenfranchised under House Bill 589 who wouldn't be disenfranchised under Senate Bill, a majority of whom wouldn't be disenfranchised under Senate Bill 824. You hadn't looked as to whether those individuals had voted on election day, correct?
I had not at the time of my deposition, correct.
You also, in your report, testified about the importance of safeguarding voter confidence, correct?
I did.
In your opinion you offered in your report, you stated that even if every eligible voter votes, no foreign or internal interference occurs, there are no counting errors with voting equipment, and no evidence of fraud or irregularities. If the public doesn't believe it, there's no confidence in elections, correct?
Yes.
Now, when you say quote unquote, no confidence in elections, you do not mean that everyone in the state has to question the election's legitimacy, correct?
In every election, there's going to be people that are going to question the election. No, that's not my goal with that sentence. No.
Okay. To you, in your report, there is quote unquote no confidence in an election when there's a general view in the public or questions about an election or the results of the election. Is that how you
Yes.
explained it?
Yes.
But you can't tell us how many people need to have this view before an election has no confidence, correct?
I don't think you can put a number on it. I think it just is, like I said, if you have if there is a sense in the state or in a community, if it's a particular smaller election, that that the election was not conducted fairly, even if it were conducted fairly, that can decrease the confidence people have in that election. If there is, and I say that because of a lot of disinformation and misinformation that we have seen in current elections that goes around about the accuracy of an election.
Sure. And you're not aware of any studies that have quantified or measured voter confidence in elections, correct?
No, I've not looked at any study.
And you've not conducted any studies on North Carolina voters' confidence in elections, correct?
No, I have not.
And you've never used a consistent system or methodology to capture feedback from individual voters on their confidence in elections, correct?
I have not.
You'd agree that one way to instill voter confidence in elections is to ensure that eligible voters are not wrongly excluded from casting their ballot, correct?
I do agree with that.
You're not aware of any empirical data that measures the fraud deterrent effects of voter ID laws, are you?
I am not.
And you don't have any evidence to suggest that a belief that voter fraud is obviated by the imposition of a photo ID requirement affects voter confidence, correct?
I have not looked at any studies.
Isn't it true that the state of Georgia has a photo ID requirement?
Correct. Yes, it does.
And isn't it true in this past election in Georgia, there were still mass allegations of voter fraud?
Yes, and Georgia is a great example of my point, is that you had lots of different allegations, not all not collected necessarily with the photo ID requirement. And what you had was an elections board that was able to come out and explain why those allegations could not be true, why the safeguards they had in place made those allegations not factual. And that was my point, is that even if you can come out and explain how you know that a particular type of fraud or irregularity didn't occur or is unlikely to occur, that builds confidence with your electorate, because they understand that you're aware of those concerns, and not only you're aware of it, you're doing something to try to combat it. And that's what Georgia, I think, did, which increased the confidence likely in those results.
And you're aware, aren't you, that lack of confidence in the Georgia results resulted in thousands of people storming the Capitol on January 6, 2021, demanding lawmakers stop the steal of the Georgia election, aren't you?
I don't think it was just Georgia. I think that was not just because of Georgia. That was that was in part of our former president calling into question the results in many states in which he did not win. So once again, you have someone that is laying doubt in an election, and that can cause people not to have confidence. And I think that's exactly what we saw, is people didn't have confidence because they were told that the elections in the states were not accurate.
You agreed with me at deposition that there was no evidence of any election fraud or voter fraud in Georgia, correct?
I agreed with you. I did not see, I thought the allegations that were made, I thought the election officials there explained what actually happened and did not seem to have merit.
And you do not believe that widespread voter impersonation fraud exists in North Carolina either, correct?
I do not think we have any evidence that it exists in North Carolina. And so I have not seen any evidence to suggest we have widespread voter impersonation in North Carolina.
You do not believe there is widespread voter impersonation, correct?
As I said, I've seen no evidence to suggest that that is the case.
Any claims to the contrary would be baseless, correct?
Without evidence would be right. You would have to show some evidence that it's actually occurring.
Thank you, Ms. Stark. That's the end of my proffer cross-examination pursuant to our agreement with the legislative defendants. I'll reserve the right potentially, but hopefully not, to do some cross on LX 188, but I'm optimistic we'll resolve that tonight and it will be unnecessary for me to do anymore.
All right, thank you. Mr. Cox, do you have cross-examination questions for this witness?
Thank you, Your Honor.
Ms. Moss, do you have redirect?
Thank you, Your Honor. If I could, I'd like to start with just a brief proffer redirect in response to the last line of questioning from Ms. Riggs, and then I'll move off of that to just regular redirect, if that's okay with the court.
Sure.
Your Honor, may I just request that Ms. Moss let me know when she's done with the proffer?
Not a problem.
Thank you.
Okay. Ms. Strzok, you recall just being asked about the Georgia elections, is that right?
Yes.
Okay. Do you know whether allegations in Georgia involved their absentee balloting process?
I think there might have been some allegations with respect to their absentee balloting process. There were numerous allegations.
Do you know in Georgia, was there a photo ID requirement to vote absentee in the last election?
I don't believe, right. I don't believe that I don't think their photo ID requirement extended to absentee by mail voting.
And in your opinion, if there had been a photo ID requirement in place, would that have been an additional tool that the election officials in Georgia could have pointed to with respect to allegations of fraud in the absentee balloting process to provide assurance to Georgia voters that the election had been conducted fairly?
It would be another safeguard that they could show was a reason that they were able to identify any fraud if it were in fact happening.
And Your Honor, that's the end of my proffer. So, Ms. Strzok, do you recall both on direct and then in Ms. Riggs' cross-examination discussion of early voting hours in 2012 and 2016?
Yes, I do.
Okay. And if we could bring up an exhibit that we've marked LX 270. Ms. Strzok, do you recognize this document? And we can scroll down for you if need be.
You could. Yes.
Okay. And do you recognize this document as a press release that was issued by the State Board of Elections while you were the executive director?
Yes, I do. And it was.
Okay. And the title of the document, if we can go back up. SBE, that is State Board of Elections, is that right?
Yes,
So SBE, early voting begins in North Carolina, and the document is dated October 20th, 2016.
correct.
Okay, if we could go down to the next to last paragraph. Do you see in this document where it states county boards of elections offices across North Carolina have scheduled more than 42,400 total hours of early voting for the 2016 general election, a 16% increase over 2012?
Yes.
Also, the 444 early voting locations statewide is a 21% increase over 2012.
Yes,
Is that consistent with your recollection and your testimony today?
it is.
I now want to turn your attention to the line of questioning that Ms. Riggs had about the 1,248 voters that you identified in the presentation to the General Assembly's Joint Oversight Committee. Do you recall Ms. Riggs asking you if you had any way to know how many of those voters were told to return and chose not to because, I'm sorry, how many of those voters were not told to return to provide their ID before canvass?
Yes,
Objection to the extent this, trying to think how to phrase this. This was to the extent this is expert testimony, it was undisclosed. At the time of her deposition, Ms. Strack didn't know these numbers.
Ms. Moss, you wish to be heard?
Yeah, I didn't ask her the number. I was asking her if she recalled a question that Ms. Riggs elicited an answer from her on. So I'm not clear, you know, I'm not clear what that objection would be. This was a question that Ms. Riggs asked Ms. Strack.
Okay,
Oh,
I'm
the
sorry if I
objection-
misunderstood the question.
The objection's overruled. Ask your next question.
Okay. So Ms. Strack, understanding that you don't know the number of voters who may not have been told about the option to bring their ID to the County Board of Elections before canvass, do you know the number of voters who may have chosen not to return to the County Board of Elections office because the election was over and the results had already been essentially decided?
no, I don't.
Objection. This is the analysis done under the guise of an expert report that was undisclosed expert analysis and not offered in her reports.
Your Honor, Ms. Riggs opened the door to this line of questioning by asking Ms. Strack what she knew or did not know about this number. I'm merely following up on the question that Ms. Riggs herself posed about what Ms. Strack knows about that 1,248 number.
The objection's overruled. You may answer the question.
No, I don't have any way of knowing the number of voters that were told and just chose not to come back after Election Day was over and show their ID.
When you were with the State Board of Elections and doing the provisional auditing following the March 2016 primary, were there discussions within the State Board about the possibility that that was a reason why voters did not bring their ID to the county boards?
Yes.
Do you also recall being asked if you could have done an analysis of the racial breakdown of the various numbers that you reported to the
Yes.
General Assembly? Okay. Could any member of the General Assembly who wanted to have that information have asked you to provide it?
Yes.
And similarly, you were asked about a no match analysis and whether you were asked to perform, whether the State Board of Elections was asked to perform an updated no match analysis in 2018. Do you recall that line of questioning?
I do.
Again, could any member of the General Assembly have asked you to perform that analysis if they wished?
Yes.
And if you had been asked to perform that analysis, would you have been able to provide the General Assembly with a complete list of registered voters who lack qualifying ID under Senate Bill 824?
Can you state the first part of your question again? I'm not sure I understand.
Sure. If you had been asked to perform that analysis, would you have been able, based on the data available to the State Board of Elections, have been able to provide the General Assembly with an accurate list or number of registered voters who lack qualifying ID under Senate Bill 824?
I don't believe so, based on the matching exercises we had done and the responses to those matching mailings. I'm not sure that I could not say to them that this is an accurate number of voters that do not possess acceptable ID.
And I believe in response to one of Ms. Riggs' questions asking about whether you did any analysis of the effectiveness of the outreach campaign that the State Board of Elections had engaged in prior to the March 2016 primary, that you measured the effectiveness in turnout. Did I understand that testimony correctly?
That's correct, yes.
And what is your understanding, based upon your experience and your tenure with the State Board of Elections during that election, what the turnout was for the March 2016 primary as compared to prior elections?
Well, there were 2.3 million, which was the largest turnout in a primary in North Carolina history. So that was, and with that, the number of people that actually brought their ID. Those two factors were indicators to us that the outreach campaign had been successful, had reached the vast majority of the 2.3 million voters that voted.
Okay. And finally, I want to ask you about some of the voter impersonation, voter fraud line of questioning that Ms. Riggs asked you about. In your experience during your tenure as executive director with the state board, was it your understanding that every potential instance of voter impersonation was detected and reported?
If it was happening, there would be it's a very difficult election crime to detect. Because especially with early voting, and you have sites where anyone can come, you don't have to be in your own precinct. So if it in fact were to happen, unless someone in that polling site knew that individual, it would be difficult to detect it. So while I have no evidence that there is any widespread voter impersonation going on, I can't state that it hasn't gone on, because it's a difficult election crime to detect.
And finally, Ms. Strzok, do you recall being asked your opinion on whether poll workers might choose affirmatively or not to offer assistance, or to ask if assistance is needed in as part of the provisional balloting process for photo ID?
Do I remember that question?
Yes.
Yes, I do.
Do you have a view as to whether poll workers will offer assistance if asked?
Objection calls for speculation.
Again, Your Honor, Ms. Riggs opened the door by asking her broadly, without qualification, quote, poll workers might choose affirmatively or not to offer assistance, or to ask if assistance is needed. And I'm just following up on that question.
I asked what was in the station guide.
The objection's overruled. You may answer the question.
It is, poll workers understand that their role at the polling sites is to assist voters voting. That is through getting them through the process. So I have no reason to believe that a poll worker during early voting or on election day would not provide assistance to any voter that requested it, or if they had the belief that a voter needed assistance, asking them if they needed assistance. That just completely seems reasonable to me, and there's nothing that I have in my knowledge or experience that would tell me different.
And do you recall being asked about a demonstrative that showed alleged decision points that poll workers would have to make as part of the provisional balloting process?
Yes.
And in your experience, are those decision points that a poll worker would have to make regarding essentially all types of provisional ballots?
Yes,
With
I believe.
perhaps I'm sorry, with perhaps the exception of, having to review, I think,
Sorry, yes.
scrutinize for reasonable resemblance.
Now, I'm glad you stated that. Yes, I think that, right. And Senate Bill 824 doesn't have a reasonable resemblance requirement. But yes, aside from the scrutinizing of the ID in that demonstrative, that the precinct official, if there is any problem with the voter needing to not being on the rolls or having some issue that they can't comply and go forward to get a ballot, they would all go to the help station for any provisional reason, not just photo ID, but for any provisional reason.
With the same reservation that depending, and hopefully plaintiff's counsel and legislative defendants will come to an agreement on the one disputed exhibit, I have no more questions for Ms. Strzok at this time.
Recross, Ms. Riggs.
Just one, Ms. Strack. Senate Bill 824 does in fact require the precinct official to verify that the photograph on the ID the voter is presenting is that of the person seeking to vote, doesn't it?
Yes, and I'm not sure if it's exactly the same language as 589, but I'm sorry, I stand corrected. It has some ability for them to have to look and make sure that the ID is that of the voter.
Thank you. No further questions.
Mr. Cox, do you have questions?
No, thank you, Your Honor.
Ms. Moss, do you have further questions?
Not at this time, Your Honor.
Okay. Ms. Strzok, thank you very much for your testimony. You're now free to leave the courtroom.
Thank you.
Mr. Thompson, do you have any further witnesses?
Your Honor, we don't have any further witnesses. We have the issue over pages 3 and 4 of LX 188 where there's underlying factual information, and we're trying to work with our friends for the plaintiffs to get that in a format that we can share in summary format. If not, then we'll move in the underlying highly confidential information from JX 798 and other related materials. We also are working with the plaintiffs on the designations and counter designations of Mr. Culp's deposition. I think we're very close to having an agreement on that. And with the court's permission, we would just reserve the LX 188 issue until we've tried to work that through with the plaintiffs.
Okay, do you have other exhibits that you would like to introduce at this time?
I believe there may be a couple. Is that right, Ms. Moss?
That is correct.
Okay, I will hand it over to Ms. Moss.
All right. So, Ms. Moss, understanding about LX 188 and the Fred Culp deposition, what other exhibits would you like to admit at this time?
We would like to move into evidence LX 257, which is a document that was used with Mr. Neesby in his direct entitled Maintaining the Voter Registration Database in North Carolina.
All right, LX 257 is received.
Then we would also like to move in exhibits used with Ms. Strzok, understanding that her report JX50 and JX51 are only offered for proffer, and so setting that aside and setting aside LX 188, we would like to move into evidence LX 191, which was the summary exhibit on provisional ballots in Alamance County.
Your Honor, briefly, plaintiffs would object to moving in any exhibits that were used during legislative defendant's proffer examination of Ms. Strack, given that the proffer testimony is not evidence in this case.
Okay, well, you're right that the proffered evidence is not substantive evidence in the case. It's only been made part of the record for purposes of appeal and for purposes of allowing each party to make a proffer. I guess the question is whether or not LX 191, the summary exhibit of Alamance County, was talked about during proffer.
It was not, Your Honor. None of the exhibits, apart from her two reports, which we didn't question her about, but all of these were used in regular non-proffered examination. of
That
Ms.
was my
Strzok.
recollection, Mr. Simons.
Your Honor, we also believe that LX 191 was offered during the proffer examination of Mr. Reed, one of the plaintiff's prior witnesses, and the court sustained plaintiff's objection to LX 191 as outside the scope of Mr. Reed's knowledge, and therefore not an acceptable exhibit for him to opine on, given that he was testifying as a lay witness.
Okay. The objection is overruled. LX 191 is received.
We would also move into evidence LX 192, which was the summary of reasonable impediment ballots not counted in Guilford County in the March 2016 primary.
No objection from the plaintiffs, Your Honor.
LX 192 is received.
We'd move in LX 202, which was the Guilford County election results from the March 2016 primary.
No objection.
LX 202 is received.
And then we would move in LX 209, which are the one-stop voting sites for the November 16, 2012 election.
No objection.
LX 209 is received.
LX 210, which is the one-stop voting sites for the November 3rd, 2020 general election.
No objection.
LX 210 is received.
LX 219, which are the one-stop voting sites for the November 8th, 2016 general election.
No objection.
LX 219 is received.
We would move in for demonstrative purposes only LXD 220, which was the demonstrative of the Guilford County one-stop sites compiled from LX 209, 210, and 219.
To the extent offered only for demonstrative purposes, plaintiffs have no objection.
LXD 220 is received for demonstrative purposes.
Next would be LX 224, which were the election results for Alamance County in the March 2016 primary.
No objection.
LX 224 is received.
And then finally well, not finally, but next to finally, LXD 258, we would move in for demonstrative purposes only. And this was the demonstrative used with Ms. Strzok to show the various spreadsheet columns in the provisional ballot spreadsheet for the March 2016 primary, which the underlying spreadsheet is JX 798.
To the extent this exhibit is offered only for demonstrative purposes, plaintiffs have no objection.
LXD 258 is received for demonstrative purposes.
And then finally, LX 270, it's the State Board of Election press release on early voting in 2016 that was used with Ms. Strzok on her redirect.
Your Honor, plaintiffs object only because plaintiffs have not received a copy of this exhibit and wish to review.
And we can certainly provide it. It came up, we determined or identified it to use on redirect. So we just identified the exhibit and we can shoot a copy over to them.
Well, I'll wait till they see it before I rule on whether or not it gets admitted. But if you'll just star that one and come back to it. And Mr. Simons, once you get it, you have no objection, you can let Ms. Moss know and we can readdress it at that point.
Thank you, Your Honor.
And Your Honor, apart from dealing with the LX 188 summary exhibit and whether we're going to be able to resolve that and whether there'll be a need to move in any other exhibits related to that or be able to redact other exhibits needed other than that issue and the deposition designations, that is all that we have at this moment.
Okay, assuming those things get resolved overnight and that you rest, you would be resting just after that, right?
Yes, Your Honor.
Okay. Mr. Cox, will there be evidence for the state defendants?
Your Honor.
So what would you like to do now, Ms. Riggs, Mr. Thompson, Mr. Cox? I see Kevin Quinn is in the waiting room, and I assume he's here for rebuttal evidence. Understanding that the legislative defendants have not yet rested their case. Would you like to go ahead and hear part of his rebuttal?
Your Honor, oh, well, sorry, Mr. Thompson. Mr. Quinn, Professor Quinn is ready to testify and to keep us on schedule. If legislative defendants have no objection, we'd love to start with his testimony.
And we're happy to proceed in that fashion, and Mr. Patterson will be handling the questioning of Dr. Quinn for us.
And for the state defendants, my colleague Terrence Steed will be handling any questioning.
Who will be handling it on behalf of plaintiff?
Your Honor, my colleague Taylor Williams.
Good afternoon, Your Honor.
Good afternoon, Mr. Williams. So it's Terrence Steed for state defendants, Pete Patterson for legislative defendants, and Taylor Williams for the plaintiff, right? Is that all correct?
Yes, Your Honor.
Yes, Your Honor.
Okay. I will say this, and maybe you can give me a forecast of this, but I've talked to the other judges, and we feel fairly strongly that the rebuttal evidence in this case should be true rebuttal. In other words, it should rebut the other evidence that has already been introduced. It is not a time to introduce new evidence. It is a time solely for the introduction of rebuttal evidence. And so that's the framework within which we are going to hear this evidence and view it. And I simply bring that to your attention and commend it to you for your consideration as we rule on objections and other things. There may be a reason why we sustain an objection as being outside the bounds of rebuttal that we're going to be very attuned to. And with that in mind, how long do you think, Mr. Williams, this rebuttal for Mr. Quinn will take?
Your Honor, my best estimate is that it will take about half an hour.
All right. And other than Mr. Quinn offering evidence in rebuttal, what other witnesses will offer rebuttal evidence on behalf of the plaintiff?
Your Honor, tomorrow Senator McKissick will offer rebuttal testimony, and I would imagine his direct to be approximately 15 minutes.
Okay. I think that keeps us on schedule. As you'll remember, tomorrow our schedule is going to be a little different, 9 to 1. So it's our normal Friday schedule. If we finish earlier than 1, then that's certainly okay. But we do have those parameters within which to work. Okay. All right. We can let Mr. Quinn into the courtroom. Mr. Quinn, can you? I see him appearing and then disappearing in the waiting room. But Mr. Quinn, can you hear me? Okay.
I can, Your Honor. Good afternoon.
Okay. Great. Good afternoon to you. Welcome back.
Thank you.
You're still under oath. You've previously been placed under oath in this case, and so just remind you that you're still under oath. And Mr. Williams, you may ask your first question of this witness.
Thank you, Your Honor. Good afternoon, Professor Quinn. We've met before, but for the record, my name is Taylor Williams from the Paul Weiss firm on behalf of the plaintiffs. Thank you very much for making time to come back and testify today.
You're welcome. Good afternoon.
Professor Quinn, did you listen to Dr. Janet Thornton testify at trial?
I did, yes.
Did you hear any new claims during Dr. Thornton's testimony that you were previously unaware of?
I did, yes.
What were those claims?
So the major claim that I heard that was new was a claim that I removed 500,000 license numbers from the DMV file that had canceled, suspended, or inactive codes prior to doing my matching analysis.
Do you agree with that claim?
No, I don't think that's an accurate claim at all.
Have you investigated that new claim?
I have, yes.
Professor Quinn, did you draft a declaration responding to this new claim?
I did, yes.
I would now like to publish to the court Plaintiff's Exhibit 124, which is a rebuttal declaration that Professor Quinn prepared on April 27th in response to Dr. Thornton's testimony, and which has been previously disclosed to defendants. Professor Quinn, why did you draft a declaration responding to this new claim?
I was shocked by how misleading Dr. Thornton's testimony was on this issue of how I handled canceled, suspended, and inactive licenses.
And to make sure the record is clear, did you in fact remove 500,000 people from your matching analysis because they had canceled, suspended, or inactive IDs?
No, I did not.
What is your understanding of whether canceled, suspended, and inactive DMV issued IDs are acceptable for voting under SB 824?
My understanding is that they're not valid forms of ID and thus are not qualifying forms of ID under SB 824.
In light of this understanding, can you explain why you decided to include canceled, suspended, and inactive DMV IDs in your matching analysis?
I can, yes. So one might think that there are some situations where an individual may have such a license, a canceled, suspended, inactive license, and still be in possession of it, and may try to vote with that license and be allowed to vote with it, even though it's, right, I don't think necessarily legal for them to do so. And so the idea of including these forms of ID as possible matches was an attempt on my part to be conservative, to lower the number of individuals on the no match list. It was an attempt to be cautious.
Did you measure in this declaration how many individuals were included in your matching analysis with the status codes?
These non-active status codes.
Correct.
Yes, I did.
Ashley, can you move to page 3 at paragraph 5, please? And in total, Professor Quinn, how many individuals with the non-active status codes were included in your matching analysis?
There were about 1.5 million DMV records that were included with these status codes.
Professor Quinn, have you measured what would happen if you were to exclude licenses with these status codes from your matching analysis?
I have done that, yes.
What did you find?
So this shows up in my December report. What happens is that the racial disparity that I found, the ratio of 1.39, in other words, African-American voters being 39% more likely to lack qualifying ID than white voters, that disparity actually increases if one excludes these non-active forms of ID. That ratio goes up to about 2.1. Which would mean that African-American voters are over twice as likely to lack these forms of ID than white voters if they're excluded.
Professor Quinn, having investigated Dr. Thornton's claim, what is your understanding of why she thinks you excluded 500,000 records?
So in her testimony, she made reference to, I think her terminology was programming logics in the code that I produced for my matching analysis. And what I take that to mean is that when she reviewed my data processing steps, I believe she misunderstood how I was handling some of the data processing at the very beginning.
And can you explain that data processing for the court?
Yes, I can. So at a very high level, the DMV file has a subtable with status codes that are linked to license numbers. And there are duplicate records in that table. What I did was to deduplicate that record. This is a standard sort of data processing procedure called deduping or deduplication. And what I did for individuals who have an active record linked to a particular driver's license number and also some sort of inactive record that is linked to that exact same driver's license number, I made the choice to prioritize the active license status for that record. So I dropped the inactive status code, but the driver's license record remained. There were no individuals dropped.
And what does it mean when someone has multiple status codes?
So my understanding is that in this DMV data, that typically corresponds to an individual with multiple licenses.
Did the DMV provide you any materials that explain how status codes are used in the DMV customer database?
They did, yes.
What materials are those?
So the primary thing they provided was an Excel spreadsheet that functioned as a data dictionary for the data files they produced.
Okay, I would now like to publish to the court Joint Exhibit 268, which is the DMV Customer Database Data Dictionary. Do you recognize this document, Professor Quinn?
I do, yes.
What is it?
It's the data dictionary I spoke of just a second ago.
Did you rely on this data dictionary when performing your matching analysis?
I did, yes.
Your Honors, plaintiffs move to admit Joint Exhibit 268, which is the DMV data dictionary produced in this case.
Any objections?
No objection from legislative defendants.
Plaintiff's exhibit 268, or actually it's joint exhibit, I think you said 268, is that right?
That's right, Your Honor.
Being the data dictionary is received into evidence.
Thank you, Your Honor. Professor Quinn, today I'd like to focus on the file layout tab in this document, but to give the court a sense of the information contained here, let's briefly look at the first tab titled Saddles Data Dictionary. What information is shown here?
So in this tab, what we're given is information about the table names that were produced, as well as the data elements that are within those tables. And then there's some additional columns that provide more human readable or human understandable descriptions of what those data elements are.
And moving to the next tab titled Code Types, what information is shown here?
So in some of these tables, there are some fields that have a small number of categorical values. And rather than writing those full values out in those data files, what the DMV is doing is using a single alphanumeric code to represent that information. And this tab provides the translation between that alphanumeric code and what that alphanumeric code actually means.
Looking at row 14 on this Code Types tab, for example, do you see where it says driver status codes?
I do.
Do these terms we've been discussing today, including canceled, suspended, and inactive, refer to the status code that the DMV maintains for each DMV ID?
Yes, that's correct.
And are all of those status codes shown here?
Yes, I believe so.
Okay, let's move to the final tab titled File Layout. Professor Quinn, what is a file layout?
So you can think of this tab as providing information about the underlying files or tables that were produced by DMV. So there are a number of separate tables that are linked together by driver's license number. And so what's going on here is this tab is providing us with information about what resides in each of those files. So if we're looking at the driver ID file right here, we see there's the driver's license or identification number. That's a unique identifier in that file. And so for each of those driver's license numbers or identification numbers, we know a number of things from this table. We know the license group code for that driver's license number. We know the license class code for that driver's license number. We know the license issue date for that driver's license number. And we know the expiration date for that driver's license number. This also provides some detail about where these various fields reside within this file. It also gives us a count of the total number of records in this file. And then the last column provides the name of the zip file that was actually produced.
Okay, and how many files are described in this document?
8 files.
Generally, is it possible for one DMV customer to have multiple DMV IDs?
Yes, multiple licenses or, yes, that's correct.
Can you provide an example of where one person might have multiple licenses?
So one example would be, suppose there's an individual with, say, a Class A license, and that individual applies for a commercial driver's license. That person would have a commercial driver's license permit for some period of time, while simultaneously having the Class A license.
Does this driver ID file that you described to the court include all of the data you need to match DMV issued ID against the voter file?
This particular driver ID file that we're looking at right here.
Does that contain all of the data that you need to make a match to the voter file?
No, it does not. It only includes the driver's license number and some information about the expiration date and some other information about the license itself.
Where does the rest of the DMV data you need for your matching analysis come from?
So that comes from other files or tables that are described in this file layouts tab.
Okay, so if we move to row 23, Ashley, do you see the residential address file?
I do.
Did you include that in your matching analysis?
I did, yes.
And can you give a very brief summary of what information is included in that file?
Yeah, I can. So again, we see that we have driver's license number or identification number here. So this identifies an individual. And for that individual, we have some information about their residential address, where they live. 2 address lines, their city, their state, their zip code.
Okay, and Ashley, let's move to row 34, please. Do you see the citizen file here?
I do.
And again, can you give a very brief explanation about what information is included in this file?
I can. So again, we have driver's license or identification number. That's what we're using to index into this file. And for each of those driver's license numbers or identification numbers, we know the first name, last name, birth date, race or Hispanic origin, last 4 of social, and if the individual is deceased, the date that they passed away.
Thank you. Ashley, can we move to row 50 now? Professor Quinn, do you see the status file described here?
I do.
Okay, and can you explain to the court what information is contained in the status file?
I can. So the status file is one of the simpler files in this production. There are only 2 fields. There's the driver's license or identification number again, and then there's a status code that is associated with that. The important thing here is that driver's license number or identification number is not unique in this file. There are some individuals that have multiple entries for the same driver's license number because they have different status codes that correspond to that license number.
Okay, so just to make sure I'm following, earlier you shared that one person could have multiple licenses. Does it follow then that an individual with multiple licenses might have multiple status codes?
Yes, exactly.
Okay, one for each license, is that right?
Correct, yes.
Ashley, can we please move to row 50, column I? Dr. Quinn, does the data dictionary speak to the issue of a person having multiple status codes?
It does. What we're seeing here in that note that was put into this file by DMV, it states the majority of the DMV customers will only have one status record. However, if the customer holds multiple licenses, such as classified and a CDL permit, then the customer will have a status record for each license.
Ashley, you can go back to column A, row 50. So this status code file that we are discussing, is this related to Dr. Thornton's claim that you dropped 500,000 people with canceled, suspended, and inactive status codes?
Yeah, it is. Yes. I think the issue is that she may have misunderstood how I was working with this file to remove the duplicate status codes.
Okay, Ashley, we can take down this document. And let's please go back to PX 124, Professor Quinn's declaration, and let's look at table 2 on page 4, please. Professor Quinn, looking at table 2 here, are these the DMV customers with multiple entries in that status code file we talked about?
Yes, that's correct.
Do each of the individuals represented in this table have multiple licenses?
They have multiple driver's license records. So some of those people may have a non-operator's ID, but yes, if we're using driver's license to refer to both non-operator IDs and driver's licenses, yes.
Thank you for clarifying. Can you explain how you handle these records with respect to your matching analysis?
I can. So this gets to the deduplication point. So for an individual who has multiple status codes attached to their record, there's some uncertainty of how to match the voter file record to those various status codes. And so the important thing here is that an individual driver's license number may have multiple status codes. The driver's license numbers refers to an individual. And what I did is for individuals who have multiple status codes, and one of those status codes is the active code, I prioritize the active code. So when connecting the status to the rest of the information from the DMV files, the citizen file, the license expiration date file, etc., I chose the active status for that type of person. And I did not choose the non-active statuses that you see there.
How often does this situation where an individual has multiple status codes appear in the data?
There are 482,040 such individuals.
Okay, and how do these 482,000 DMV customers relate to the claim made by Dr. Thornton?
So to the best of my knowledge, I think what's happening is that she's rounding up, that the 500,000 that she's talking about are these 482,000 people. The important thing to note is while I'm dropping status codes, I'm not dropping driver's license numbers, I'm not dropping individuals who have active licenses.
And to be clear, did you use status codes in your match strings that we've previously discussed?
I did not, no.
Okay. Ashley, you can take this down. Thank you. Given all this information, what is your conclusion regarding Dr. Thornton's claim?
I don't think it holds water. I think it's very misleading at best.
All right, thank you, Professor Quinn. I have a few final questions on your April 27th rebuttal declaration. Ashley, can you put PX 124 up briefly? Professor Quinn, did you draft this declaration?
I did, yes.
Is your opinion on the subject that we discussed today captured in your declaration?
It is, yes.
Okay, and moving down to page 6, Ashley. Is this your signature, Professor Quinn?
Yes.
And when did you sign this declaration?
On the 27th of April of this year.
Your Honors, consistent with the party's previous stipulation regarding expert reports, plaintiffs moved to admit PX 124, Professor Quinn's declaration, into evidence as part of Professor Quinn's rebuttal testimony in this case.
Is there any
No
objection to that?
No objection from legislative defendants, Your Honor.
None from the state, Your Honor.
All right, plaintiff's exhibit 124 is received into evidence.
Thank you, Your Honor. Professor Quinn, I just have a few final questions for you. In the testimony from Dr. Thornton and Mr. Neesby, do you recall there was also reference to a DMV file that may have been maintained in 2015 called the driver history file?
I do remember them speaking of that, yes.
What is your recollection of that testimony?
So, as I recall, I think there were sort of two things that came up. Mr. Neesby seemed to point to the existence of this file in 2015. And I believe there was also a second claim that despite being called a history file, this file was not purely historical data, that there were actually unexpired current IDs in this history file. And as I recall, Dr. Thornton referenced Mr. Neesby's points on this issue.
And what is your understanding of that 2015 driver history file?
I can't really say much about it other than what I've seen in the reports and in the testimony. It's not a file that I had access to. It's from litigation from 2015, not the current litigation. And I don't really, I'm not really able to say very much about it because it's not a file I have access to.
Ashley, you can take this down, please. Professor Quinn, based on our discussion of the DMV data today, is a file that was produced in this case, is there a file that was produced in this case where multiple issuances of DMV IDs would be captured?
Yes, as we talked about, the status file that we just talked about is an example where there's information about multiple IDs.
Do you have any reason to believe that you are missing individuals in your matching analysis who have multiple IDs?
From what I've seen, the information I've received from DMV, no, I don't think that's a problem.
Thank you, Professor Quinn. We have no further questions.
All right, Mr. Patterson, you have cross-exam?
I do, Your Honor. Good afternoon, Professor Quinn. Good to see you again. I'd like to start at PX 124 and go to Table 2, which you discussed during your testimony. Okay, and this is a table, it's titled Summary of Individuals in DMV Database with Multiple Status Codes. And I just want to make sure that I understand what is in this table. So the first, at the top of this table, this indicates that you found 477,680 licenses with non-active status codes for individuals whose information in the DMV file was also associated with a license with an active status code. Is that correct?
If by license you mean some kind of DMV issued identification, yes. It's important to note the license number is the same for those. So for instance, the individuals in the first row who have an active license and some sort of inactive e-license, those are all referring to the same driver's license number or customer ID in the DMV data.
Okay, so so to make sure I understand, these individuals have one DMV issued identification with a non-active code and another DMV issued identification reflected in the database with an active code. Is that correct?
I believe that's correct, yes.
Okay. And then if we move down to the second set of individuals in this table, this indicates that you found 4,360 DMV issued IDs with non-active status codes for individuals whose information in the DMV filed was also associated with at least one other DMV issued ID with a non-active status code. Is that right?
I would phrase that slightly differently. What I would say is that 4,360 number represents the number of customer IDs or driver's license numbers that have two or more inactive status codes associated with them in the status file.
Okay. So altogether in this table, there are 482,040 individuals whose information in the DMV file is associated with at least one non-active status code. Is that right?
Yes, that's correct.
Okay, now I'd like to go down to paragraph 7, which is the paragraph immediately beneath this table. And I'd like to go to the sentence that starts in my analysis, which is kind of at the top of, toward the top of page 5. So you
Is
say,
it okay if I pull up a hard copy?
absolutely. And so here we're on page 5, the sentence starting in my analysis toward the top there.
Okay.
Okay, so you say, in my analysis, I dropped the non-active licenses for these 482,040 individuals from the DMV database prior to my matching analysis, but retained the active licenses. Is that correct?
That's what that states, yes.
Okay, and so that indicates that you dropped about 500,000 non-active licenses from your analysis. Is that right?
Yes, it's important to note that I did not drop individuals. I did not drop license numbers. There was no information that was lost that was relevant for the actual matching itself.
Right, but you dropped these about 500,000 non-active licenses, correct?
For those individuals, I prioritized the active license.
And you dropped the non-active license.
I dropped the status code for those individuals. That was the non-active status code.
Okay, and the total number of non-active status codes that you dropped was more than 482,040 because some of these individuals had more than one non-active status code associated with their records. Is that right?
If one were to double count some of the driver's license numbers, it would be more than that. That's right.
Okay, now I'd like to go up to paragraph 2 of this affidavit. And there you state, the new claim made by Dr. Thornton relates to how I analyzed DMV license records with the status codes of canceled, suspended, and inactive in my matching analysis. When asked to confirm her understanding of my methodology on cross-examination, Dr. Thornton issued a new claim that my analysis dropped about 500,000 licenses with the status codes canceled, suspended, and inactive from the DMV database prior to performing my matching analysis. Dr. Thornton's claim is false. How is Dr. Thornton's claim false when you just acknowledged, and you wrote in paragraph 7, that you dropped about 500,000 non-active licenses from your analysis?
I think the context around Dr. Thornton's testimony, as I recall it, was that I was dropping driver's license numbers and hence individuals, and hence this had an effect on my matching analysis. What I did had no effect on individuals who had an active license code in the status file. All of their information remained. I didn't drop any of those individuals from the DMV database prior to the matching analysis.
But it is not false that you dropped about 500,000 licenses with the status codes canceled, suspended, or inactive, is it? You wrote that you did that in paragraph 7.
I dropped the status codes for individuals who had multiple licenses, and I kept the active license.
Okay, if I don't want to belabor this, but if we go down to paragraph 7 again, just to refresh what you wrote there. You said, in my analysis, I dropped the non-active licenses for these 482,040 individuals, correct?
That's what that states, yes.
So it's not false to say that you dropped the non-active licenses for about 500,000 individuals, is it?
Objection, Your Honors. This question has been asked and answered a number of times.
The objection is sustained. So it's now 5 o'clock, and this may be a good time for us to go ahead and break for the day. We'll start back tomorrow morning at 9 a.m. The schedule again for tomorrow will be 9 a.m. to 1, we will continue tomorrow morning at 9 a.m. with Dr. Quinn's cross-examination on rebuttal by Mr. Patterson. Is there anything before we recess for the day?
Not for the legislative defendants, Your Honor.
Not for plaintiffs, Your Honor.
Not for the state, Your Honor. Thank you.
Okay, hope that you all have a good evening, and we'll see you back here tomorrow morning at 9 a.m.
Thank you.
Be in recess.